Hello everyone, welcome back to the channel Legalese. We have discussed till now about the jurisdiction, and this is a video in which we will be discussing about the objections to the jurisdiction of the court. Here we will understand how the jurisdiction can be objected, at what stage and on what grounds. So let's quickly start our video. If you have not subscribed to my channel, please subscribe to it and click the bell icon so that you will get notified about the videos that I make on CPC time again and again, and it will help you in preparing for your competitive exams as well as your law or any other exam that you are looking for wherein you have chosen law. Okay. Coming to the objection to jurisdiction given under section 21, it has three subsections. First and second subsections are very much related. The only difference is that first subsection is related to objection in relation to the territorial jurisdiction, while the second subsection is related to the objection to a jurisdiction which is a pecuniary jurisdiction. That means if a court does not have a territorial jurisdiction, then you can challenge it as per subsection 1. If a court does not have a pecuniary jurisdiction, then you can challenge it as per subsection 2. The third subsection talk about the challenge of an executing court's jurisdiction, that whenever a decree gets executed, then how can you challenge the jurisdiction of that executing court? Now it says whenever a court does not have a territorial jurisdiction or a pecuniary jurisdiction, then after the decree is passed, you can obviously file an appeal. When you will go for an appeal, the appellate court or the revisional court, if you have filed a revision, will not take up that particular matter until and unless you prove two things. The first thing is that you have raised the objection of absence of jurisdiction in the lower court or the court of first instance at the earliest possible opportunity, and that earlier possible opportunity is set as the time before or at the settlement of the issues, or in addition to that, the second condition is that there has been, and word is used, so both these conditions have to be fulfilled, that there has been consequent failure of justice. Similarly, for pecuniary as well, the same thing is written, that in the lower court, you have to prove that an objection was raised before or at the settlement of the issues, which is at the earliest possible opportunity, and you have proved a subsequent failure of justice. So once you prove both these things, then only the court will take it up that the lower court did not have the jurisdiction, and the appellate court can set aside the decree of the lower court. First, let's understand these two by way of examples. So generally what happens in any suit, when you will go to a court, you will file a plaint. After the plaint is filed, suit is considered as to be instituted. After that, the court issues summons. The summons are served, and then after service of summons, time period is given to file the written statement at appearance. After written statement is submitted, if there is any document transfer has to be done, if there is any inspection of the documents has to be done. If there is any interrogatories needed to be filed, we will make videos on these things as well, that these are given under order 11, then that time will be given, and then the court will fix a date for first hearing of the suit. On this first hearing, the issues are framed, that is given under order 14. When these issues are framed, either on that day or before the day of the framing of the issues, you have to raise all the objection. You have to raise the objection related to the jurisdiction. So let's suppose plaintiff has given jurisdiction to court A, and the defendant think that the court A does not have the territorial or pecuniary jurisdiction. Then before this particular issues are settled on this day or on the day when the issues are actually settled, before that or on that day, the defendant has to raise this objection in this court A only. If he has done this, then and the court A did not listen to him, and instead of the objection, a decree is passed, then you can file an appeal or revision against this decree. And when you go to the revisional court, then or appellate court, then you will say that you raise this objection before the time period given or at the within that time period. In addition to that, once you prove this is the first thing that you will prove. In addition to that, you will prove failure of justice. So consequent failure of justice along with this, that when the decree was given, this decree has actually resulted into failure of justice to the parties. If they have not been able to prove the failure of justice, and just that the court did not have the jurisdiction and the objection was raised, is not sufficient to declare this or to set aside this decree passed by a court which do not have the jurisdiction. So for both pecuniary and territorial jurisdiction, objection should have been raised before or at the settlement of the issues, and consequent failure of justice have to be proved. After that, the third point that is given is related to executing court. Again, in the executing court, if the court has executed a decree and then you are saying that the court which has executed the decree do not have the jurisdiction, then you will file an appeal or go to the revisional court against that execution done by the executing court by saying that the court did not have the jurisdiction. But in the appellate or the revisional court, again you have to prove two things: that the objection was raised at the earliest possible opportunity and consequent failure of justice. यहाँ पे settlement of issues की बात नहीं की गई है. The reason being, the settlement of the issues happen when you are taking the case for the first time to be decided on the merits. When you are going for execution, the case is not decided on merits. It has already been decided. It is just executed of the decree which is passed by deciding the merits. तो यहाँ पे earliest possible opportunity वो court के ऊपर depend करता है. What is the meaning of the earliest possible opportunity? So this is it under section 21. Now, as you can see, the section 21 provides only for territorial and pecuniary jurisdiction. It does not say anything related to the subject matter jurisdiction. How can you challenge it, or what will be the consequences if a court gives a decision in absence of subject matter jurisdiction? So the answer to it you will get in detail in the case of Harshad Chinman case, which I will show you, or and I will write the name in detail in the description box as well. So in this particular case, it was said that if a court gives a decision without or in absence of subject matter jurisdiction, the decision will be void ab initio. मतलब टेरिटोरियल और पेक्यूनरी जुरिसडिक्शन के बिना अगर डिसीजन आता है तो वहां पे आपको चैलेंज करना होता है, एंड यू हैव टू प्रूव दीज टू थिंग्स, then only you will be able to show that the decision of the court is wrong or decree is needed to be set aside. But if the decision is given without the subject matter jurisdiction, then in those cases the decision will be void ab initio and cannot be executed. So आप चैलेंज अगर कर रहे हो अपीलेट कोर्ट में, तो आप सिर्फ टेरिटोरियल पेक्यूनरी जुरिसडिक्शन के लिए ही आपको ये प्रूव करने की जरूरत है. सब्जेक्ट मैटर के लिए आप डायरेक्टली appellate court को बोल सकते हो that since it did not have the subject matter jurisdiction, the case is void. You do not have to prove anything in furtherance of that. This is the case that I was talking about. You can read this case, and in case of any doubts, you can always contact me, and I will always be there to solve your doubts. You can mention it on the comment section. So this is it for today. Thank you and have a nice day. Bye bye.